Welcome to Money, 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 your weekly personal finance date with me, Surabhi Upadhyay. Life is uncertain and unfortunate circumstances can strike any time. Now, such events leave not just an emotional but also a financial impact on those who are left behind, which is why having a will and a proper plan with respect to your estate, your properties, is a real must. And that is exactly what we will focus on today's show. My guest is Neha Pathak, Senior Vice President at Motilal Oswal Wealth Management. Thanks very much, Neha, for dropping into our studios. It's a very, very important subject that we're dealing with, and I think one that at times, particularly, the urban middle-class Indian in their busy lives tends to overlook till it's sort of too late. So you look at all aspects relating to estate planning. What all does it sort of comprise? Is it just about creating a will? Is that the bedrock of the succession plan that we're speaking of?
So, Surabhi, it would not be only a creation of a will. We would also look at what your assets are and how best you can transfer it in case something happens to you. So, to give you an example, if I have a client who wants to transfer everything to his son to take care of his wife, however, if he holds everything jointly along with his wife, the transmission may get a little more difficult because the joint holding is with the wife. So that is why we have to go through each and every asset. So making a will and stating that in case something happens to me, everything goes to my wife can get a little difficult. So you have to go through each and every asset class and the holding pattern to decide how the asset will go from one person to the other.
Okay, so before we even get started, let me understand how the law works in case there is no will. If you simply pass away without any sort of documentation, any statement of your intent, then in that case, let's say, what would the rights of the wife be? Or if it is the lady passing away who has substantial assets in her name, what would the rights of the spouse be? And then where would the rights of the children lie?
All right. Now, in India, we have something called personal succession laws. Unlike other countries where there are uniform codes, in India we are trying to implement uniform code. That is not at the moment, it's in the process rather. But in India we have something like a Hindu Succession Act or a Shariat law. So every caste or religion has their own laws.
Sure.
So in case if a Hindu male passes away, then in that case the asset is divided equally between all his wife and his children.
Okay.
And even the mother will be forming a part of that.
Okay.
So it depends really which caste you belong to, which personal religion do you follow, and accordingly one would decide how it will happen.
So just to take that point forward, as far as a Hindu male is concerned, you said the mother also has a certain right. Again, is it equally divided? What does the Hindu law say?
So it's basically mother has to be maintained. So since old age thing has continued that the son is supposed to take care of the mother, the same thing continues over here also in the laws.
Okay, but there is nothing stipulated in terms of a ratio or a proportion in the law?
For wife and for the kids, it's equal proportion.
Okay.
So that way. And if we move to the Muslim law, it's absolutely as per the Shariat law. There are percentages divided.
Sure.
So depending on number of children, your wife, your brother, so there are a lot of relatives that are defined over there, and accordingly the percentages are divided over there.
Okay, so it's the Hindu law or the Muslim law, as the case might be, that will prevail if there is no will.
Yes.
Now
I would like to correct you there. So in Muslims, only 1/3 of the estate can be dealt with.
Okay.
Not 100%. By will, you can only bequeath 1/3 of the estate.
All right.
Not 100%.
The remainder will have to go as per the Sharia law.
Yes.
Okay.
In Hindus, you can deal with the 100% of it.
Okay, so if we, for the sake of the discussion, now we look at the way the Hindu law is worded and what that allows you to do. If there is no will, then as we just discussed, there is, the children's rights, the mother also has perhaps a stake, and of course there's the wife. Now, if there is a will, that obviously should make the whole process a little more amicable and easier perhaps.
Yes.
what are the first steps? I mean, and I think people also have, this notion of, oh, but really do I have that much of saving? Maybe I just have some 50, 60 lakhs across deposits, maybe some shares. Do I really need a will? So is there a threshold you advise clients above which a will is, important?
Will is basically, it is not, you should not look at a threshold for a will. A will should be formed irrespective of the quantum of wealth that you hold.
Sure.
So it's as simple as this. I hold one property, I have a bank account, I have job, I have PPF, I have gratuity. I better have a will in place.
Okay.
Because I might have done some error somewhere. I might not have changed nomination. As simple as that. And nominee gets everything when we talk about the financial assets, at least for the financial bit. So for a simple thing like this, when I started working, for most of the people, we were not married. And it so happens the nominee is still your sister, or your father, or your mother. In which case, if something happens to you, the asset goes to them and doesn't go to your wife or your children whom you actually intend to give. So that is why it is always advisable that have a will in place.
Absolutely. And the will is going to override any previous nominations that you may have with respect to these assets, whether physical assets or financial assets?
So there is a back and forth that keeps going between law and what the will says and what the law says.
That's where lawyers like Neha come into the picture. Absolutely. Okay. So that's obviously, a matter of debate and a matter of law. But let's come down to the brass tacks now. To start off with, my understanding is that you can actually write your will on a piece of paper and get two witnesses to look at it, and it will hold water. Is that right?
That's
how do you begin?
correct. That's absolutely correct. So you can pretty much write the will saying that I'm so and so, and I'm fully conscious of what I'm doing, and my assets go to whoever I wish intended to give it to, and sign it. Get it signed by two witnesses, and that's a proper valid will, actually.
Okay.
But if you make this, you're not securing everything 100%. So might as well secure it properly by saying that the assets will go to such and such person in case something happens to me, and detail the assets.
But as you said, this does hold legal muster.
Absolutely.
But there's also the question of probate.
Yes.
Making the will absolutely legal and, getting a court seal on it.
Yes.
So do explain that process to us and its importance. Is it necessary to get this probate?
So probate is a process where there is an executor who's mentioned in the will. So executor is this person who will take the will to the court and say that this is the last will of the deceased, and accordingly execute the will, and thus have the assets transferred from the person, from the deceased person's name to the people who are mentioned in the will.
Okay.
So who are the beneficiaries. So executor is like an administrator of a will.
Sure.
So he will go to the court, get an order. If the order comes in their favor, it is known as the probate decree.
Okay.
If it is contested, so this is the time people can go ahead and contest the will. They can say that this will is not legal, or the assets which are mentioned should come to me, or he owes me money, so creditors can come forward. So all these things can happen while an executor goes to the court to probate the will.
Okay.
So probate is an order from the court, saying that the assets which are mentioned should go to the rightful beneficiaries who are mentioned in the will.
Okay. So this is when there is no challenge, or challenges have been put to rest.
Yes.
And a favorable order is granted to the executor of the will by the court.
Yes.
Okay. Now, one of the things that always comes up, or many times comes up, is this question of sound mind. And we hear of stories where the soundness of, the person's mind is being questioned.
Yes.
How does law define sound mind, and what can you do as a person who is writing your own will to ensure that it's less prone to legal challenge from different parts of the family, etc.?
So we generally recommend this, that have a doctor's certificate put in place. So whoever is your general physician or a family doctor, the onus is upon them to give a certificate saying that the person is of sound mind and physical health and can go ahead and make the will.
Okay.
So you attach that to your will.
Okay, so that will make it a little more watertight.
Yes.
And less prone to sort of litigation and challenges. Any other sort of things that you would have seen in your experience where wills get contested and it ends up getting into a long drawn sort of fight, and perhaps it's stuff that people can try and avoid?
Yeah, so a lot of people actually in India, they think will is a taboo subject to talk about in the family. So they think that talking about the will is talking about a death. And thus they do not talk about it, or if they form it, they hide it in some cupboard or give it to a relative to safekeep, and never ever talk about it. So in case the relative shifts the house or the relative is not there anymore, that will which was made by the actual person, that is also not there.
Okay.
Then in that case, people don't know. The expectations are different from what reality is. So that is why people would want to contest the will.
Okay.
They may want a different part of the asset, and actually what might have been given to them would be a totally different part.
Okay. Okay. So it's important to, I think, have a clear discussion and at least let the main family members know that there is a will in place.
Absolutely.
Okay, well, on that note, we're going to take a break. So we've got the basic hygiene questions out of the way. There are certain category of people, perhaps people who are residing out of India, who might find the going a little more tough when it comes to executing this will. So we'll discuss this and other details on the other side of this break. Welcome back. You're watching Money, 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 and this week we are discussing a very, very important subject. Generating wealth and creating wealth is fine, but have you ensured that you will pass it on to your future generations in a proper manner? And the way to do that is to have estate planning in place, the need to have a will in place. That's what we're discussing with Neha Pathak of Motilal Oswal Private Wealth. So Neha, we've discussed some of the basic issues and how one can get started with a will. My question is this, can all kinds of properties, financial assets, can anything be put in a will? And what happens to assets which are not residing in India? I mean, for the rich and wealthy who maybe have a UK house that needs to be sort of, part of the planning process, or property in Dubai, etc. How are those assets dealt with?
Okay, so every jurisdiction has to be dealt with in a separate manner. So if you have a will in India, you can include every kind of asset that you have in India in that will. You can actually mention about the assets which are there outside India also in the will. However, the way it should go would not be as per that particular country's law. So to give you an example, like a country like Dubai has got a uniform code, which means that Shariat law would apply on each and every person who is residing in Dubai. So if a person passes away in Dubai, and if he has assets such as land or such as a bank account, or he has got business interests over there, then in that case the assets would go as per Shariat law. It would not go as per what he has mentioned in a will in India.
But this is when the person is passing away in Dubai, in that jurisdiction.
If he has, even if he is passing away in India, but he has assets in India, in Dubai, then in that case also on those assets, the law of the land would apply.
So the Sharia is going to apply for those assets in Dubai, if that's an example that we are taking.
In which case one has to go to Dubai, they have to make a proper will over there, they have to convert it into Arabic or Urdu, and register it with the concerned authority over there.
Okay, so then it's not as simple as saying, okay, my sort of UK house is going to go to this family member, or my property in Singapore will simply go to this particular daughter. So it doesn't work like that. You have to go jurisdiction by jurisdiction and see what the law allows over there. I was just talking about the type of assets. So property, financial assets, perhaps art, valuables, anything can be included in a will?
Anything and everything can be included in a will. So you have a collection of stamps, you have got collection of swords, you have got arms collection, you have got jewelry, you have got a specific jewelry that you would want to give to a specific grandchild. All those things can be mentioned in a will.
Okay, fantastic. Now I just want to touch upon this issue that perhaps some NRIs face, and you were telling us about some of the experiences. I mean, you deal with clients all the time. Is it a little more difficult for those Indians who are residing out of India to go through this process of will, then going and getting a probate? How can they look at these things?
So what happens is, an NRI actually, when he is residing outside India, in that case, he cannot take care of the property as if he was over here. So for a simple thing that I have a piece of land and I want to grow something, I don't want people to encroach upon that land. How do I protect that? So NRI cannot keep coming back to India to check on that, or a PI cannot keep coming and doing that, because they have their own work over there. Plus, if you go to see, there are certain investments which are there, which are open to NRIs. If he wants to make those investments, how does he go about that particular issue? If you go to see if there is a flat, simple thing, if we have a flat or a house that we want to put it on rent. So most of the NRIs, they take investments in India as residential assets.
Sure.
Then they want to put it on rent and then sell it off at some point of time. Now, for doing any one of these things, if he wants to put it on rent or if he wants to sell it or he wants to purchase a new property, then in that case, he would have to be physically present over here.
These are assets that this NRI has inherited. That's what we're assuming.
Yes.
Okay.
Then in that case, inherited or acquired over the years.
Okay.
Either one of the two.
And eventually would want to pass them on to their next generation.
Yes.
Okay.
Then it gets very difficult for them to handle these kind of things. So how are you supposed to stop an encroachment while you're sitting in US or you're sitting in Nairobi? If you are having a flat, how do you put it on rent? You have to be physically present over here. So these are the problems which NRIs face. In which case we tell them that instead of holding these assets in your personal name, you hold it in a trust name.
Okay.
Now these trusts the trusts I'm talking about are private family trusts.
Okay.
Private family trusts are formed under Indian Trust Act. They are nothing like a charitable trust. So there is no ATG requirement over there or register it with the Charity Commissioner. It's a simple private trust which is formed by the family members for the family members. Now is recognized by Section 56, which talks about relatives in income tax. Now, when you keep an asset in a trust, what happens is you don't require probate. So if somebody is inheriting a property from an individual, then they have to apply for probate.
Correct.
Right? If you are benefiting from a property which is forming a part of a trust, in that case you don't need to go through a probate process.
Okay.
A trust is not subjected to probate.
So for instance, if I have created a trust which has all my properties, financial, physical, jewelry, etc., and then I need to do my succession planning for, let's say, children, relatives later on, then the trust creates a will. What about member trustees? How does it work?
So what happens is when you are creating the trust, at that point of time you are making a trust deed in which you are going to be putting down what are the objectives of the trust. So the objectives can be to provide for your children, for their marriage, for their education, or to provide for your grandchildren, to make sure that the assets are not given out on lease or on loan, or there is no borrowing or lending in the trust. So there are a lot of clauses that are there in the formation of the at the time of the formation of the trust. Now the job of the trustee is to adhere to these clauses and follow. Those will be his guidelines. So he has to follow those guidelines.
Okay.
Now the beneficiaries can directly benefit from the income of the trust.
Okay.
Or they can you can put a period over there. Say, for example, after 50 years, the property will get transferred in my son's name or my daughter's name.
Okay.
Then in that case, the property would get transferred from the trust into the beneficiary's name.
Okay.
But people generally prefer that the benefit keeps going to the beneficiary rather than the property or the asset itself. So corpus keeps building up, and the benefit keeps going to the beneficiaries.
Okay, okay. Well, that's food for thought. So for those who do want to look at a slightly more evolved, perhaps, a process of approaching their estate planning, they can look at the trust route as well. We need to take a quick break on that note. On the other side, the all-important T word, taxes. When you're looking at will and succession planning, estate planning, where do taxes come in? What is it that you need to keep in mind? We will discuss that after the break. Welcome back. You're watching Money, 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 and this week we are discussing the very important issue of creating a will and planning and managing your estate. What happens once you pass on? Then are those assets going to be handed down to your future generations smoothly or not? Well, Neha, so coming down to the very important issue of taxation. Now, right now in our country, there is no concept of an estate duty or an inheritance tax. But what are the other kind of taxes you need to still keep in mind when you're looking at creating your will?
So you have to keep in mind the inheritance or inheritance tax or estate duty, because at this point of time we don't have it in our country, but at a later date it may be introduced.
Okay.
Also, one needs to keep in mind that in other countries this tax already exists. So
is it as high as 40 to 50% in certain countries?
Yes.
If my memory serves me right?
Absolutely.
Wow.
Japan has it at 55%.
Wow.
Yeah.
So if you're getting, let's say, an asset worth ₹1 crore, 50 lakhs straight away goes to the tax man.
55 lakhs.
55 lakhs. I mean, taking the Japanese example.
Pretty much half of it goes.
Wow. Okay.
Yeah.
We don't have that right now, but who knows tomorrow? Never say
Yeah.
never. So therefore, that's something to keep in mind. What else from a tax point of view should one consider?
So tax point of view, one should consider these taxes at least, and one should also keep in mind that tomorrow, if your children want to plan their estate, so you have made certain capital during your life, your children will also make capital. So together it makes a very large chunk. So tax-wise, one has to wonder that would it come under the Land Ceiling Act? Would it come under capital gains would come into play? While creating any kind of thing, anything, be it a will, be it a trust, be it any kind of estate plan, the simple taxes would be, you have to talk about all the income tax rules, you have to talk about the capital gains, short term, long term, you have to think about the Land Ceiling Acts, and there are various other acts one needs to keep in mind before you go ahead and implement an estate plan.
And for instance, when capital gains comes into the picture, then it will be capital gain over the entire period. You could have held that asset for 30 years and then it's sort of inherited by your child who holds it for another 5 years. So it's 30 plus 5. Eventually, whenever that asset is sold off, it's going to be the entire period over which the taxation would apply, right? Does the trust structure help in any way in whatsoever when it comes to smarter tax planning?
For the inheritance tax bit, it is the best structure. Worldwide, it is used for tax saving against inheritance tax.
Because it's not applicable to...
So the trust has to be formed in a particular method and a particular way, so that the person who is forming the trust, his assets do not come under the estate planning, inheritance tax purview.
Okay.
So there is a certain limit or a threshold beyond which there would be estate tax that will be applicable.
Sure, absolutely. So going back to our central point, the creation of a will and getting a probate from the court. How long does the process typically take, and what are the typical legal costs? I mean, I'm not asking for an exact number, but all the fees involved, going to the court, getting this probate, roughly from a urban Indian consumer's point of view or a client's point of view, what should one keep in mind?
So it will take, if we are lucky, anywhere between 3 to 6 months.
Okay.
If one is lucky, if everything goes well. If it is contested, it can take, I don't know how many years, nobody knows that.
That's true.
The fee would range because, like, if I have to talk about Bombay, the High Court has got a fee of 70,000 for admission of the testamentary petition, which is basically applying for probate.
Okay.
And after that, there would be court fee and other ancillary charges which are there.
Okay.
So it can become an expensive affair if you look at it from a long-term point of view.
Okay.
So now it's been a very, very long time that the court has not revised the fee. So there's a possibility there might be a revision of the fee, and for sure the advocate's fee is much more than the court fee.
Absolutely, the court fee. That has to be, absolutely. So Neha, final advice, tips or sort of final suggestions that you'd like to leave our viewers with as they start looking at this process of planning for their future?
So I can always suggest, so let's not make ourselves the lawyers, let the lawyers do their job. So though people can make a will on their own, they should actually engage a lawyer who can create a proper will for them, or get a proper advisor who can do it for them. And same thing would apply for creation of any kind of estate. So that would be my final note for everybody.
Okay, I think that's a lot of sound advice. Thank you very much, Neha. Important food for thought, things to keep in mind as we're looking at not just creating wealth, but ensuring that it's properly secure and it passes on seamlessly to the next generations. Thanks very much. Very enlightening conversation. Well, do let us know what you think. Your feedback, queries and comments are welcome as always. We'll see you again next week. Thanks for watching.